Welcome to today's Explainer. We are opening up a highly documented, incredibly serious case file right now, and it has some profound implications for basically anyone who participates in local government. We're looking at a central conflict here. What actually happens when citizens use completely lawful tools to interact with their government, and instead of just being heard, they find themselves targeted by an elected official? We're going to dive deep into the evidence, the documents, and the exact timeline of the Legislative Ethics Board complaint involving Jay Tabor and State Senator Sharon Shewmake.
To really understand the stakes here, the foundation of this entire case file can be summed up by a single, powerful quote directly from the record. What happened to Jay Tabor should concern every citizen in Washington. Because honestly, this isn't just some localized dispute in a small town. The official state documents we're about to walk through raise some incredibly alarming questions about the boundaries of political power and how citizen advocates are or aren't protected.
Think about the basic tools of democracy for a second. The foundation of civic engagement really relies on a few specific, entirely lawful mechanisms. And according to the record, Jay Tabor was simply utilizing these exact tools. He was acting as a citizen exercising his constitutional rights. We're talking about filing public records requests, giving public comment, engaging in environmental reviews, and filing police accountability complaints. These are absolutely standard, lawful ways to demand transparency.
But here is where things take a massive left turn in the documentary record. The ethics complaint alleges that instead of being treated as a citizen just exercising those fundamental rights, Jay Tabor was explicitly targeted and branded as a harasser. The core allegation is that his lawful participation was deliberately repackaged as an abuse of the system. So you're probably wondering, how did that actually happen? Well, let's look at the primary evidence.
The turning point of this whole situation hinges on an official piece of paper. On May 18, 2026, Senator Sharon Shewmake sent a letter printed right there on her official state Senate letterhead to the interim executive director of the Criminal Justice Training Commission, or the CJTC. Now, this is crucial. This letter was sent specifically regarding an ongoing active investigation into several Blaine police officers.
Let's look closer at the actual text of that official letter. Senator Shewmake wrote that residents were, quote, weaponizing and abusing these systems. This group has filed countless records requests, consuming staff time and city resources. The really important takeaway here is that this correspondence went way beyond just general legislative policy. It directly attacked the credibility of specific complainants in an active police investigation, framing their perfectly lawful open government activity as harassment.
Now, a comparative analysis of the record reveals exactly how this narrative builds, and this is pretty wild. On the left side of the record, we have a claim from October 2025 made by David Brudvik, who happens to be a convicted felon. He introduced this hostile narrative accusing the citizens of utilizing AI technology to bombard the city. Fast forward 7 months later, on the right, we have Senator Shewmake's official state letter claiming the exact same thing, that citizens were using AI voices. The evidentiary record strongly suggests the senator's official correspondence just mirrored these highly idiosyncratic hostile fabrications that originally came from local municipal insiders and a violent actor. And then, the situation escalated significantly. That state Senate letter didn't just sit quietly in a legislative file somewhere. According to the complaint, it was actively weaponized to prejudice a live law enforcement accountability investigation.
The documentary trail picks back up a few weeks later on June 10, 2026. Rebecca Singleton, the attorney representing Blaine Police Chief Roger Funk, sent an email directly to the CJTC investigator. And what was attached to that email? Senator Shewmake's official letter. The police chief's defense counsel actually submitted the senator's letter as a defense-side exhibit to push back against the complainants and their allegations.
And right there, in that exact same Juneteenth email, we see this absolutely critical detail. The defense attorney relayed a claim attributed directly to Chief Funk, stating that the FBI was declining to investigate local corruption and, quote, were in fact flagging all the complainants in their system. The case files show this completely unverified claim was used right alongside the senator's letter to systematically discredit the very citizens who had filed the police accountability complaints in the first place.
So when you combine all of this, the official state letter, the mirrored fabrications, and the submission of that letter into an active investigation by a defense attorney, you get exactly why formal ethics complaints were filed on June 26, 2026. Jay Tabor brought these complaints against the senator directly to the Washington State Legislative Ethics Board.
Which brings us to the absolute core question the Legislative Ethics Board is now being asked to evaluate.
Looking at this case file neutrally, here is the exact issue at hand. Did a state senator use her public office, her official title, and her state letterhead to help discredit citizens in a pending police accountability investigation?
Now, legally speaking, the complaint operates under a specific framework within the Washington Ethics in Public Service Act, and it relies on 3 distinct legal theories. First up is abuse of official position, which addresses whether a legislator unlawfully intervened in an executive branch investigation. Second is special privileges, focusing on whether that official position was used to unfairly give a credibility advantage to Chief Funk and city officials. And third is the use of public resources, questioning if state letterhead and staff time were burned on a letter that lacked any legitimate legislative nexus, serving instead just to protect local insiders.
Let's map out the chronological chain of custody of this disinformation, because it clarifies exactly how this all unfolded. In October 2025, the hostile AI narrative is first introduced by a felon and municipal insiders. Fast forward to May 18, 2026, and Senator Shewmake essentially launders that narrative into an official state letter to the CJTC. On June 10, the police defense attorney formally submits it to investigators to discredit the citizens, and finally, on June 26, the citizens strike back legally by filing the Legislative Ethics Board complaint. It is a perfectly mapped chain of custody.
So, what happens next? Well, the Legislative Ethics Board has a pretty serious to-do list now. They are tasked with answering several urgent, factual questions. Like, who actually requested this letter be written in the first place? Who supplied the senator with these highly specific, completely fabricated claims? Were Blaine City officials involved in coordinating all this? And ultimately, did this state-sanctioned letter improperly give a credibility advantage to Chief Funk during a misconduct investigation?
As the source material explicitly notes, this is so much bigger than the city of Blaine. This isn't just about whether a senator is allowed to have a personal opinion on something. It's about whether the literal authority of the state can be leveraged to chill public participation. When citizens use public records, environmental reviews, and police complaints, they are just participating in democracy. That's it.
I want to leave you with a final provocative thought derived straight from this evidentiary record. If elected officials can take lawful public participation, reframe it as harassment, and turn it into a weapon against their own citizens inside a police investigation, is democracy itself under attack? If official power is used to punish civic engagement, the chilling effect is absolutely undeniable. Citizens across the state should be paying very, very close attention to how the Legislative Ethics Board handles this case file.